Welcome to the Berkeley Symposium on Same-Sex Marriage, Law, and Politics. This afternoon event is being co-sponsored by the UC Berkeley Institute of Governmental Studies, IGS, and the Institute for the Study of Social Change, ISSC. My name is Mark Levin, and I'm the Assistant Director of the Institute of Governmental Studies and the Symposium's lead organizer. On behalf of both institutes, I am very pleased and honored to open this public event. We have gathered a very distinguished group of participants today who have agreed to come here in the spirit of academic freedom and open dialogue. Several participants have traveled across the country to be here and to be heard. Our topic today, same-sex marriage, is controversial, divisive, contentious, and emotional. Our panelists come from a broad spectrum of influential special interest organizations, academia, the professions, and public life. Taken together, these 12 participants represent the range of opinions and forces that are shaping this public policy debate. The origins of this symposium go back to November 2003. At that time, Bruce Kane, the IGS director, and I were walking into work one morning and discussing the breaking news out of Massachusetts concerning its state appellate court decisions on allowing same-sex marriage. Bruce said to me, "Mark, I believe this matter has the potential to be a major issue in the 2004 presidential election, and we should organize an academic gathering on this dispute." Well, Bruce, here we are 5 months later doing just what you suggested. Bruce, thank you for your inspiration, your insight, and instincts for allowing us to organize a public service activity for the university of this nature. The debate to define state-sanctioned marriage has touched off a political maelstrom across the country. We hope that today's program will serve to educate and explore this controversy. This program is within the Berkeley tradition of creating a forum for free speech and open exchange of ideas, no matter how passionate. I ask that the audience be respectful and civil during these proceedings, even if you personally disagree with statements you might hear today. Let UC Berkeley lead the way in creating open forums on the great issues confronting our society today. Today's event will consist of two parts. The first panel will be moderated by Professor Rachel Morin, Raven Professor of Law here at UC Berkeley. Her panel will explore the legal, constitutional, and public policy dimensions of this topic. The legal panel consists of 8 participants and will operate as a roundtable discussion. The second panel will be moderated by Professor Bruce Kane, Robson Professor of Political Science at UC Berkeley. His panel will address the politics surrounding this issue and will host 4 experts. If time permits, at the close of each panel, we will offer an audience participation segment. Under your chairs, you will find question cards. These are to be used if you want to pose a question during the question and answer session to participants. One of today's panelists, Professor Evan Gerstmann, in the preface of his new book on today's topic wrote, quote, "Same-sex marriage has become a front-burner issue in American constitutional law, and things are moving rapidly. The most interesting events are yet to come." With this sentiment, I hand the symposium over to Professor Moran. Thank you for joining us today.
Thank you very much. It's a pleasure to be here today. In this first panel, what we're going to do is begin with a 5-minute statement from each one of our panelists, and then we're going to pose a series of questions, any one of which they can be free to answer. I will introduce each panelist as he or she speaks. Let's begin with Carol Migden, who is the chair of the California Board of Equalization. Previously, she served in the State Assembly, where she authored legislation to create California's Domestic Partner Registry. Her public service also has included 5 years on the San Francisco Board of Supervisors, and currently she is a candidate for the State Senate.
Thank you. Thank you very much. I'm very pleased to be here with this group of academics and distinguished panelists, as political scientists, legal scholars. My mother would wonder what I'm doing here, but you'll tell her. You know, and here we are at Cal, which is the greatest public education institution in the world, and this august assemblage is convened to have an erudite discussion of same-sex marriage. I'll tell you, that's a victory in itself. And the fact that in America and throughout the globe today, people are debating same-sex marriage at their dinner tables regularly, that's a victory in itself. And in the brief time that I have apportioned to me, I want to make several points which I think attest to the timeliness and the inevitability of the acceptance of gay marriage. First of all, I'd like to say that America's families have been redefined, and gay families are just part of new and evolving family units in society today. Less than 25% of American households adhere to that old Ozzie and Harriet standard, and if I'm dating myself, excuse me. Basically a traditional nuclear family. Look at our neighborhoods and our communities today. We have families headed by single parents, multi-ethnic parents, non-married parents, step-parents raising children from other relationships, grandparents raising kids, ethnic households which can be multi-generational, lesbian and gay parents, children who are born from artificial insemination or in vitro fertilization, a vast majority of couples adopting foreign-born children of different ethnicities often, and lesbians, particular lesbian households who have the heart and humanity and often adopt children that may have HIV or other diseases like fetal alcohol syndrome. My point is that lesbian and gay families are just one facet of a broader societal definition of family that's in evidence today. Gay families and other new families are being assimilated into a changing mainstream culture, step by step, every day. Half of the Americans polled recently in the New York Times said half support legalizing same-sex unions, and about 40% support lesbian and gay marriage. And as a long-time activist in the trenches, you start at 40%, ladies and gentlemen, that's not a bad place to start. That can only do better in time. And I believe the lesbian and gay community and our proponents are not losing but winning this fight. Again, you can't pick up the newspapers without reading about it, and there is sustaining coverage because there's interest. And we, the lesbian and gay community, is enjoying increasing acceptance. 7 out of 10 Americans report they know somebody gay or a lesbian, have a neighbor, have positive views. 65% of Americans, according to the LA Times, say lesbian and gay couples living together is okay. This is what's striking. Nearly 7 out of 10 young people, those under 30, support live and let live lesbian and gay marriage. Now, you want to compare these attitudes to the 60s, the 50s, the 40s. All I can say is, do you recall in 1989, San Francisco rejected a statewide vote on domestic partnership? That was 1989. So we've come so far in actually a limited period of time. In 1997, when I served in the state legislature, I tried a domestic partnership bill 3 times, and finally it succeeded in 1999. Domestic partner, that's 1999, it's 2004, but even that had to be curtailed to smooth its exceptions because it included retired workers, seniors, state workers. It wasn't a straight, flat-out domestic partner. It was a baby step towards recognition, and that was just a few years ago. Around the nation and globe, we see acts of defiance and lesbian and gay support all over. 4,000 marriages in San Francisco, in New Jersey, in Oregon, in New Mexico, All have performed same-sex marriages. Massachusetts is about to issue marriage licenses unless there's a court reversals. Officials in New York, Salt Lake City, Minneapolis, Chicago, Seattle have expressed support. In fact, Mayor Daley of Chicago was denied communion because of his support of gay marriage. That we read in the Los Angeles Times last week that certain heterosexual couples are forestalling their marriages until their lesbian and gay friends can get married too with equal rights. The new Prime Minister of Spain, what did he say? He spoke out in his first passage to Spaniards, to his people in his elected democracy. I support legalizing same-sex marriage here in Spain. That follows Canada, Belgium, the Netherlands, where, frankly, they regard the American upheaval about this, with bemusement. I also want to say that this marriage movement isn't just a political expression. I think it is broader, and it's igniting people's consciousness all over the nation and globe, and it is more cultural than political. The thousands of same-sex couples that stood outside San Francisco and braved the weather at City Hall were joyous. And they were there not because MoveOn.org had organized them. They were there for their own thriving and yearning for validation of their individual organic family units. And part of it was a deep-seated social need for affirmation that no political organizing to match, nothing that's spontaneous, genuine, loving, or extraordinary could have been composed merely through a political alignment. Please wrap up. They told me I had 7 minutes. Okay. Well, all right. The views are kind of different. Madam Elected wraps up a little bit, but not quite. So let's see where we are. We should have timed it. Religious marriage you're going to hear about, and I guess what I'd like to say is the seeking out lesbian and gay marriage is a civil right. We're looking for the state to grant marriage a license to marry, not differently than one seeks a professional license, not differently than one seeks a driver's license. There's certain criteria set forward. The government, we believe, has a responsibility to grant civil unions to consenting adults wholly and apart from religious considerations. That's a separate track, that's a private track, that's a personal prerogative with regard to one's religious training or belief. It's fine with me if certain religious communities curtail whatever they believe has to fit in order to accommodate their beliefs, but that's wholly and that's separately apart from the right to a civil union. So what we're seeking here is not separate but equal. What we're seeking here is full acceptance of a civil right that each American in our open society is entitled to, and we want very much to separate that discussion and not mingle it with issues of religion. And let me just say that a recent poll, and I know you'll hear from some individuals to the contrary, but 35% of conservatives in California now support civil unions, and 36% of residents of San Bernardino County, California, 36% say okay on gay marriage today. And I say that just speaks to the inevitability, and I believe within 10 years from today, we will have a legal institution, and this will be a non-issue for our academic discussions. Thank you.
Our next speaker is Alan Chambers. He is the Executive Director of Exodus International, which is based in Orlando, Florida. Exodus is a global network of agencies and ministries, quote, proclaiming to, educating, and impacting the world with the biblical truth that freedom from homosexuality is possible, end quote. Mr. Chambers writes extensively and speaks nationally and internationally on issues surrounding homosexuality.
Thank you. My name is Alan Chambers. I am a Christian. I'm a husband to my wife, Leslie, and I used to be a homosexual. To be clear, I did not choose my same-sex attractions, nor did I willfully adopt a homosexual orientation. But my response to both, my behaviors, were a choice. I remember being a lonely 18-year-old searching for Mr. Right. I remember the ache to have a man hold me, to protect me, to love me, and to devote his life to me. I remember thinking I'd do anything for that insatiable need. I did everything short of praying for my knight in shining armor to show upon my doorstep. I was certain beyond a shadow of a doubt that the missing piece to my life's puzzle would be found in a man. Nearly 14 years later, I am happy, content, satisfied emotionally, physically, spiritually, sexually, and relationally. My process was one of self-determination and willful choice to move beyond the box that I believe enslaves so many wonderful same-sex attracted people today. Change is possible, and I am living proof. I used to be a homosexual, and today I'm not. Had same-sex marriage been legal in 1990, I am certain that I would have tested that option. I met men whom I wanted to marry, yet today as a mature adult with a sober perspective, I realized that I wasn't searching for a man as much as I was searching for an answer, a drug to numb the pain, something to make me feel better about who I was. The law kept me from making one, if not many, life-altering mistakes. Recently, Dennis Teddy of the Weekly Standard said, "Government's purpose is not to dispense rights, but to secure rights created by nature and nature's God." The current laws saved my life and continue to save the lives of other young people like me who need life-saving boundaries. As a former homosexual, I know that this battle has little, if nothing, to do with marriage, but rather with an absolute need for social approval and acceptance. This experiment with marriage, being promoted by a few, is about silencing inward guilt, pain, and the gut-wrenching reality resident within many homosexual and lesbian people that their desires will never be completely satisfied the way they seek them homosexually. Legal endorsement and approval of same-sex marriage will simply guarantee that more lives of those today and future children will be ruined. We already live in a truly tolerant society where the law views us all equally. Neither race, nor religion, nor gender, nor age, nor disabilities can affect our personal freedoms. Our laws are created to protect the innocent. The laws in place that protect marriage do so to protect the institution that has been the bedrock of society for thousands of years, and most importantly, to protect children. A two-parent, one-man, one-woman family is the best environment in which to raise the next generation. We must do all we can to protect the family unit. Again, I am one of tens of thousands of people who have successfully changed their sexual orientation. I'm grateful for the message of change, and I'm grateful for the laws that saved my life. Thank you.
Our next speaker is Evan Gerstmann. He's an associate professor of political science at Loyola Marymount University in Los Angeles. He is author of the recent book entitled Same-Sex Marriage and the Constitution, published in 2003, and a previous book entitled The Constitutional Underclass, Gays, Lesbians, and the Failure of Class-Based Equal Protection, published in 1999. He is a frequent commentator in the electronic and print media.
Thank you. Good afternoon. Thank you to all of you for coming out this afternoon to hear us. Because this panel is set up as supposing to focus on the law and the next panel on politics, I think I want to begin with a question many people ask about the law and same-sex marriage, which is, why are the courts involved in this at all? We're a democratic society. Why shouldn't people be voting on this? Some people of good faith who are disturbed at what's happening say this should be done democratically, not be done by the courts. I want to begin by addressing that issue. In any democratic society, there's always a tension between two important concepts: majority rule and minority rights. We are a democratic society, and that should mean something. That should mean that usually the majority gets its way. If the majority wants a certain person to be president, if the majority wants certain kind of Social Security legislation, that's the way it should be. And yet at the same time, the majority can't simply do anything to the minority that it wants to do. And so we've come to a compromise. The way we try to resolve this great constitutional tension to majority rights, between majority rule and minority rights, is to say that in the great majority of situations, it's majority rules. But in certain fundamental areas of human autonomy, the minority has to have equal rights with the majority. Marriage is a perfect example of the latter category. The Supreme Court has long held that marriage is one of the fundamental rights of human beings. They've held this over and over and over again. People often say to me, do you think James Madison and the other founding fathers were really thinking about same-sex marriage? And that's generally a hostile question because obviously they were not. And I always say, well, no. Of course Madison was not thinking about same-sex marriage. But he and his fellow founders were certainly thinking about tyranny of the majority. Look at the current situation. Marriage is in a lot of trouble in this country in many ways, with very high divorce rates, even when children are involved. And what is the heterosexual majority doing about that? They're showing no stomach at all for restricting their own freedom to marry and divorce at will, even when children are involved. It is so easy for the heterosexual majority to fail to restrict their own absolute freedom to marry and divorce at will, but then point their finger at a small and relatively powerless minority and say, we are the protectors of marriage against you. And I think that's the sort of political dynamic that Madison and the other founders were very much concerned about. It's simply too late in the day to argue that same-sex marriage is not a fundamental right. The court has held this in so many different ways. Prisoners have the right to get married, even when still serving their prison sentences. Men who fail to support their children from previous marriages have been held to have a fundamental right to marry. Well, what does that mean? It doesn't mean you can marry anybody or anything you want. All rights have limits. I have freedom to speech, but I can't say things that are obscene. I can't commit perjury. So there are limits. But the fact that marriage is a fundamental right means that it cannot be denied to gays and lesbians without the government articulating strong, rational reasons for excluding them. And one of the problems the anti-same-sex marriage movement has had, and I think this is the reason why there's been such rapid movement, is they've had remarkable trouble articulating why gays and lesbians should not be married. It certainly can't be because of children. Right? I mean, 80-year-olds get married, and people think that it's charming. Nobody says you can't get married when you're 80 because you can't have children, so obviously we can't say that to gay and lesbian couples as well. All of the other reasons quickly fall under analytic scrutiny. It's remarkably difficult. So to me, this is really a question not about what do you think about gays and lesbians or homosexuality. It's simply a question of equal rights for everybody. People will often say to me, well, what about polygamy? And I think that's a question a lot of people have on their minds. And I always welcome that question because it gets to the heart of the debate. This is a debate about equal rights for everybody. Would-be polygamists are seeking a right that nobody else has, the right to marry as many people as they want. Gays and lesbians are just seeking the same right that everyone else already has, the right to marry the person they love above all others. It's funny to find myself here defending same-sex marriage in the middle of this controversy. My friends are often surprised to find out in many ways I'm quite politically conservative. I often say I have a liberal head and a conservative heart. I think that marriage is a beautiful, important institution that does need to be protected. But the way to protect it is not to keep loving adults who want to marry, who are interested in commitment, responsibility, love, out of the institution of marriage. I hear people talking about getting government out of marriage altogether and only having civil unions and leaving it to the church to marry people, which strikes me as burning down the house to keep gays and lesbians out. The fact is, same-sex marriage will produce a much less radical change in marriage than, say, the movement towards women's equality has. There is no single definition of marriage, which is now being altered. Marriage has changed enormously over the years. The full legal equality for women has had a much, much greater change than this will. This is nothing more than another small incremental change in marriage to make it inclusive to a group of people who have been arbitrarily locked out. Thank you very much.
Our next speaker is Teresa Stanton-Collette, who is a professor of law at the University of St. Thomas School of Law in Minneapolis, Minnesota. She testified recently before the United States Senate Judiciary Committee in favor of the federal marriage amendment. She also filed an amicus brief before the United States Supreme Court in Lawrence versus Texas, which a case involving Texas's anti-sodomy law, and she also filed a brief supporting the state of Massachusetts in Goodrich versus the Department of Public Health.
Good afternoon. First, I'd like to compliment the organizers of this conference for its attempt to create balance on a debate of great social significance and great emotional content. So often these conversations are engaged primarily in preaching to the choir. Those on my side of this debate talk to people who are absolutely opposed to any recognition of same-sex unions, and people on the other side of the debate talk to those who are absolutely committed to same-sex marriage, and there's not much conversation between the two groups at all. And it's incredibly important when we're talking about matters of such important political import that both sides have an opportunity to hear that conversation dealt with by people that have some level of conversance at the level that we're going to have today. So I think this is a wonderful opportunity, and thank you very much for allowing me to be a part of it. Let me begin by saying that the first speaker, Carol, and I have at least one point of agreement, and that is what is at issue today is the question of civil marriage. What is not at issue is the sacrament of marriage or religious marriage. I think that that question should not be one that we are here to debate, and not an issue that really should be a question of state control. And she made what I think is a very important point, which is what should be the heart and core of our conversation is what are the criteria that government has traditionally used in looking at whether or not two individuals are entitled to be licensed to marry in the state. And so when we hear individuals argue that same-sex couples should be either included in marriage or excluded from marriage, I think we have to look at what is the purpose of civil marriage and what does the state look at for purposes of issuing a marriage license. And historically in the United States, it has always required that there be a man and a woman. But more importantly, when that man and woman received that marriage license could always be declared void if they did not engage in one simple act. That act was not moving in together. That act was not establishing a joint bank account. That act was not entering into joint contracts. That act was engaging in the act of sexual intercourse. Why was the state interested in whether or not a man and a woman had engaged in the act of sexual intercourse, the one act that no gay or lesbian couple is capable of engaging in? Because the civil institution of marriage is about channeling one man and one woman into a permanent monogamous relationship, because through that act they run a fairly substantial risk of creating a new life. And in the creation of new life, we want to ensure that the man who has participated in that act participates in the nurturing of that new life to adulthood, a problem that we continue to experience. Notice the tremendous difficulty we have in ensuring that deadbeat dads pay child support. Notice the large increase we have had since we've instituted no-fault divorce, with the increase of single moms and children in poverty. So in fact, the civil institution of marriage is not about adult commitments, not about issuing love licenses, if you will. It is about channeling that procreative act into a permanent monogamous relationship. Now the question was posed, by Professor Gersten, well then why do we allow 80-year-olds to marry, although males may indeed still be capable of procreation, but females surely aren't, unless of course we're dealing with Sarah or other historical figures. But nonetheless, as a general rule, one might reasonably presume that we need not worry too much about procreation at that age. But the fact is, what we want to do is we want the model for young men and young women to be that a man and a woman who are going to engage in this conduct will enter into a permanent monogamous relationship before they enter into that conduct. Why do we want that model throughout society? Because we know the consequences of them not entering into a permanent monogamous relationship. We know the consequences of fatherless children are not good. We know that those children will have less economic security, less psychological security, and their academic progress will not be nearly as good. That's not to say that there are not single mothers out there through their own heroic efforts achieving unbelievable results, but that is not the model that we want to see. If in fact we continue to expand marriage to include same-sex unions, we are saying marriage is about adult commitments. It is not about ensuring the well-being of children. That is a fatal mistake. Thank you.
Now we're going to hear from Kate Kendall, who is Executive Director of the National Center for Lesbian Rights based in San Francisco, and previously was their legal director. The center is a, quote, progressive, feminist, multicultural legal center devoted to advancing the rights and safety of lesbians and their families and to doing legal advocacy and policy work on behalf of all LGBT individuals. Thank you.
Thank you. I'm very happy to be here. And unlike many people on the panel who came a long way, I'll be home in 40 minutes. So many of us, no matter where we were in the country, woke up on the morning of February 13th and saw this picture in the newspaper. Any questions? Del Martin and Phyllis Lyon were the first lesbian or gay couple, for that matter, to marry in this country. They had been together the day they got married, one day shy of 51 years that they were celebrating. And that day, I mean, this picture also, it's not my most flattering picture, but me in the background, sobbing. Sobbing because I understood how emotionally profound it was that after 51 years together, Del Martin and Phyllis Lyon had the one thing they'd never had, the dignity, the human dignity of government respect and acknowledgement of the commitment that they had made to each other and continue to make to each other. That profound message was repeated again and again and again, and I could do that over and over again and take all my 5 minutes, 4,000 plus times. And those images of couples standing in line, beamed around this country and on the nightly news, night after night after night, images of couples joyfully, publicly making that commitment to care for each other's welfare, profoundly shifted the ground. February 12th, the date that the first licenses were issued, culminated a spectacular decision by San Francisco Mayor Gavin Newsom to use his authority, as I will say mayors and governors have done in the past in this country, to ignore a state law that he believed denied citizens equal protection of the law and to abide by a higher authority, the constitutional authority, and the aspirations of the California Constitution to accord to all lesbian and gay couples the same kind of equal protection and recognition that every other couple gets to take for granted. The issue of permitting lesbian and gay couples the same equal rights to marry is, from my view, just as much an economic justice issue as it is a civil rights issue or an issue of fundamental rights. And one thing that those lines did not capture, at least in terms of the media images that I saw when I was traveling and saw the images nationally, is they did not capture the full diversity of those couples who were standing in line. White couples, of course, biracial couples, African American couples, Asian couples, Latino and Latina couples, many, many of them with children, and many, many of them having been together for dozens of years. Those couples have survived, whether it's 51 years or 5 years, without government protection and support. And we see the cases every day of the havoc that is wreaked on couples and children because the government denies this very basic and fundamental protection. Couples where a partner dies and there's no Social Security survivors benefits for the partner or their children if the deceased partner was not able to adopt. Now, if you don't think that's an issue that affects children's welfare, look at what Social Security survivors benefits provide in families where they're provided. They're the safety net. And so many of the federal and state protections that go along with marriage are about supporting and strengthening and making more muscular the commitment of one person to another through the kind of security, economic protections, and cultural acceptance that marriage provides that has always been denied to lesbian and gay couples. We know the difference it would make in the lives of these children and in the lives of these couples to have those kinds of protections and security. And I also believe that the arc of history and the arc of this history is tracking in the direction of full embracement and celebration of these relationships and these families. I do believe it is inevitable that equal marriage rights will exist in this country for lesbian and gay couples, and not because of people like me in legal organizations who are fighting these cases as we are in California, or other lawyers who have done it around the country, or activists who have been making their life's work doing this kind of work. It's because average folk sitting in the middle of America saw this picture or those images and for the first time engaged in a vigorous discourse in their own mind and with people that they love and care about. And it is those folks who are going to make the difference in how this last chapter of this fight is written. Thank you.
Our next speaker is Roger J. Magnuson. He's the Dean of Oak Brook College of Law and Government Policy, which is a distance learning institution of Christian legal education with its office in Fresno, California. In 1994, he published a book entitled Informed Answers to Gay Rights Questions. A practicing attorney in the areas of business and commercial litigation, he also speaks widely on legal and social issues.
Well, thank you very much. I come with an accolade, an analysis, and an argument in that order. I think the accolade is probably the most shocking thing I will say because my prior experiences at Berkeley have been generally as a Stanford jihadi coming up the Bayshore in an effort to slay the golden bear, who still curses the Stanford band for reasons all of you should be aware of who know something about Berkeley. But I just want to add my voice to the others on the panel and just celebrate the Institute of Governmental Studies and Mark and others who have given wonderful treatment to me and wonderful treatment to this issue. I think perhaps under the accolade theme we can all agree that too much of the discussion of this issue has been ad hominem, and while people on both sides of this issue can give their own examples, I think this is not about bigotry, it's not about homophobia or homophobia-phobia. There are serious issues that need to be addressed here by public policy makers and people interested in the law. Secondly, there's too much argument by anecdote, and with due tribute to the very articulate presentation of Ms. Kendall, This issue is not decided by pictures in the newspaper or having a nephew or having very sympathetic treatments of people who do share romantic love for one another. It goes beyond anecdote. And frankly, there's too much argument by assuming the conclusion, the old question-begging fallacy. The issue here is not whether a right is being infringed, but whether a new and fundamental right ought to be created. One doesn't have to be an Austinian legal positivist to say that the positive law is what the positive law is. And currently, homosexuals do not have the right to marry. The question is whether society wants to take the steps of adding that right to the current positive laws and rights that exist. So first of all, the accolade. Thank you very much. It's a great pleasure to be here. Secondly, the analysis. I think we have to agree on at least three things here, or at least I would suggest three things. Number one, this is a radical change. We have thousands of years of experience of various religious traditions and various social arrangements, and this is a radical change from current rules of the road that have millennia of both moral and legal tradition behind them. That's not to say that radical changes aren't sometimes necessary, but it makes very clear that, as we trial lawyers like to say, they've got the burden of proof, because this is a radical change in social arrangements. Secondly, it's not only radical, but risky, because when one does transform radically social arrangements, traditional arrangements, there's always the peril of unintended consequences. So we ought to be cautious about this. The Romans, for example, as Henry Maine points out in Ancient Law, transformed their one marriage into three different kinds of marriage, the last of which was something approaching a domestic partner law called the law of connubium. And this resulted in the temporary deposit of a person with another person. Both Henry Maine and Gibbon, in his Decline and Fall of the Roman Empire, blamed the dilution of the family bond as one of significant disintegrating factors in the decline of Rome. It's radical, it's risky, and third, it's rationally suspect. We have here a behavior that deviates from the norm. We have probably 2% of the population, maybe 1.5 to 2.5% of the population that engages in certain forms of same-sex attachment. It's not only a departure from the norm in terms of its statistical significance, but also in terms of its substantive significance. As Dr. Armin Nicolai said, prior head of the psychiatry faculty at Harvard, simulating eating is not eating, simulating being a man is not being a man, simulating being a woman is not being a woman. And this is, as Dr. Socarides said of the Einstein School of Columbia, a masquerade. It's a different form of sexual expression. Now, when we have a deviant form of behavior, we have to determine what to do with it as matters of public policy. There are three things we can do with it. We can prohibit it, and that was the case at the time of the framing of the Constitution, where every colony, ultimately every state, had a law against what they called the crime against nature. Secondly, we can tolerate it, and after Lawrence, that's the official position of the Supreme Court of the United States, that all attempts to criminalize sodomy must fall, and we can have a laissez-faire environment. Whatever you do in the context of your own bedroom is fine. Or you can give it special privileges or special protections or special dignity in the eyes of the law. That's what we're talking about here. And when we look at this, we have to look very clearly at both the group and the behaviors that characterize the group. And as talented, as fun, as many of my homosexual friends may be, we have to look dispassionately at the characteristics of this group. First, in concept. The concept of marriage, as Professor Collette so well put it, is to create a stable matrix for procreation and the rearing of children, with an emphasis on the ideal of monogamy. Many of my homosexual friends on this issue say, yes, we want monogamy without fidelity. The whole ethos of the homosexual movement, as we see from some of the statistics, is promiscuous rather than monogamous. And indeed, the experiences of people of other states that have tried homosexual marriage have not suggested that the promiscuity has diminished. Secondly, the complementarity of men and women are implicated. Plumbers and electricians know the male and the female, and there's a complementarity that's not only physical but psychological and emotional that creates the best place to nurture children. Homosexual relationships do not have that complementarity. As Dr. Socarides said, they're a masquerade of life. And third, the characteristics of the group, as much as one is sympathetic with the people who are engaged in these practices, is very disconcerting. As the Atlantic Monthly said not so long ago, it appears that 2% of the population has over 50% of venereal disease. Statistics on promiscuity and shortened lifespans and other things make this a very real concern for the homosexual themselves. So I would suggest it's risky, it's rationally suspect, and it's radical. Finally, just an argument. I think based on what we know, as Professor Collette has so well put, about the benefits of marriage, what we ought to be talking about is not diluting marriage or opening marriage to other forms of sexual behaviors, but we ought to encourage marriage. That is to say, you tax what you want less of, you subsidize what you want more of. I think based on impoverization of children from divorce and the other bad consequences of marriage that's disintegrating in this country, we ought to encourage people to get married heterosexually and stay married heterosexually, and we ought to incentivize that and put more clear blue water between heterosexual marriages and other forms of social arrangements, whether cohabiting or homosexual marriage. That's my modest argument for today. Thank you.
Okay, our next speaker is Andrew Koppelman, who is Professor of Law and Political Science at Northwestern University. He has written The Gay Rights Question in Contemporary American Law, published in 2002, and Anti-Discrimination Law and Social Equality, published in 1996, which won a Gustavus Myers Center Prize for outstanding work on intolerance in North America. His current research focuses on the legal enforcement of morals.
Thanks. So, 5 minutes I've got to tell you everything there is to say about same-sex marriage? I don't think so. There's too much to talk about there. So I'm going to start by talking about what I'm not going to talk about. I'm not going to talk about the constitutional arguments. I am not going to talk about the natural law argument that marriage is inherently heterosexual. I'm not going to talk about the issues of conflicts of laws that are raised when one state recognizes same-sex marriage and the validity of that marriage comes up in another state. I've got a book. It's over 150 pages long. I go through all of that stuff. It seemed to me that given that we're trying to have a dialogue about this issue, and since concern on the other side of the aisle that has come up again and again is the question raised by Professor Collette as to what's the purpose of marriage, or Professor Magnuson talked about the concept of marriage. It seemed to me that it's incumbent on people like me who support same-sex marriage to explain what kind of thing we think marriage is, because this is something that the other side has pressed us on, and it seems to me that it's incumbent on us to provide a response. I had a debate in print with John Finnis a while ago, who's one of the most distinguished philosophers who opposes same-sex marriage, and he observed that the idea of same-sex marriage corresponds to no intrinsic reason or set of reasons at all. And so it seems to me that folks on my side need to say something in response to this. What kind of thing do I think marriage is? Does something like monogamy make any sense in terms of the kind of concept of marriage that includes same-sex marriage? So let me try to say a little bit, just say something about that. Now, it's common ground between us that marriage is a traditional practice that realizes ends that are intrinsically good. There are others who think that marriage is not such a hot idea at all, but we'll have to engage with those in another place. The issue is whether those goods can be realized equally well outside of the tradition of solely heterosexual marriage. My claim is that marriage is not a timeless essence. It's a historical, cultural formation. And so the question shouldn't be whether the practice corresponds to a metaphysical reality, but whether the goods that have traditionally been recognized when all went well in that practice, didn't always go well, can also be realized in other social units that don't correspond to the traditional definition. I think the way to think about this is a proposal to modify marriage is ontologically similar to a proposal to modify the game of chess. Chess doesn't correspond to any intrinsic reasons or set of reasons at all. So consider someone proposes, I want to change the rules of chess so that the rook can now move diagonally one space, in addition to all the other moves it can already make. Well, you'll say if we adopt that rule, we aren't going to be playing chess anymore. We're playing some other game. And this kind of argument has been made about actual games. When the designated hitter rule was introduced in baseball, the strongest objection that was raised against it was, that's not baseball. And that really resonated with some people. Now, it seems to me that in each case, the question is whether this transformation is going to make the game a better game than the one we play now. And I don't think you can resolve that question by trying to figure out what the essence of chess is. Chess hasn't got an essence. I presume, it seems pretty clear to me, just looking at the game, that the knight was a late addition to the game. It doesn't have it has a different logic than any of the other pieces, but it's a better game with the knight than without the knight. So the question about same-sex marriage is, if we take a look at the goods that are presently realized by marriage, the connections between adults, the creating of stable households where children can thrive, is it the case that those goods can be realized by same-sex couples? And here it seems to me that the evidence is fairly massive, given the big social transformation has already taken place. There already are same-sex households, whatever you want to call them and whether the law wants to recognize them or not. And I can only summarize here a fairly already large body of evidence that those goods are in fact being realized by the same-sex couples that are already in existence. And so the question about same-sex marriage is just, is it able to realize those? I think the answer has already been answered in the affirmative. There's a last point about the consequences of recognizing same-sex marriage. Because a second argument that was made is that, well, if you adopt this conception of marriage without an essence, bad consequences will follow. Bad consequences for children, bad consequences for adults. Maggie Gallagher recently wrote that same-sex marriage affirms that children do not need mothers and fathers, and that marriage has nothing to do with babies. And so she claims that if the state endorses this message, there will be an increase in poverty and trauma caused by widespread fatherlessness. And a couple of our panelists have made the same point. I don't think there's any way to disprove this kind of claim in which the causal chain runs through the unobservable consciousnesses of millions of people, but I don't see that there's much reason to believe it either. We need to show how recognition of same-sex marriage is going to affect any father's deliberations about whether to stay with his children. So Stanley Kurtz, who makes essentially the same argument as Gallagher, writes that the association between marriage and parenthood is partly a mystique. Men apparently need to be mystified in a certain way in order to get them to stay with their children. But this seems to me to be unduly pessimistic. I have 3 kids myself. Do you really think that I stick around because I'm mystified and confused?
I think everyone's mystified and confused about whether that's the end of your remarks. Okay, our final speaker is Jeffrey J. Ventrella, who is the Senior Vice President of Strategic Training for the Alliance Defense Fund, which does legal defense and advocacy of, quote, religious freedom, the sanctity of human life, and traditional family values, end quote. He also teaches ethics and apologetics at Greenville Presbyterian Theological Seminary and Bonson Theological Seminary.
Thank you very much. I just want to echo the gratitude that I've sensed and seen now demonstrated by the producers of this event. It's been a very balanced situation, been treated well, and I want to thank you for it. We're not here today to talk about checkmates. We're here to talk about same-sex mates, and I'm going to begin empirically. We've seen dedicated, well-organized, sincere activists appeal to the courts of this land, attempting to reconfigure the very essence, the very structure of marriage, claiming that there's been a denial to marry the person we love. That's good rhetoric, but that's bad law. Now, I'm not talking about what's happening in Massachusetts or San Francisco or any other place. I'm talking about what we've seen in our American jurisprudence dealing with Utah trying to receive statehood. The polygamy battles had the same sort of issues that went on and on and on. And what was the essence of those legal debates? The essence of those legal debates constitutionally was, can we have legal recognition of a different structure of marriage, a structure that disavows one man, one woman in monogamy, so on and so forth. The Supreme Court said no. The Supreme Court recognized both the communitarian benefits to society that one man and one woman living in monogamy confer, as well as the complementary design of a male and female, as opposed to an androgynous Mr. Potato Head view of human relations. And what the court said was, marriage is, quote, the union for life of one man and one woman, which is, quote, the sure foundation of all that is stable and noble in our civilization. And so what we need to understand contextually here is, this is not a new issue. This is not a cutting-edge issue. It's not cutting edge in American jurisprudence, nor is it cutting edge in Western legal tradition. And every time there has been legal reformation that's occurred, it's always occurred with respect to tweaking the fundamental structure, one man and one woman. Never has it been obliterated. But same-sex marriage seeks to change the structure, just as the activists 150 years ago attempted to change that structure. And so we've got to do better. We've got to look at this issue dispassionately. We need to have arguments, not quarrels, but arguments, not anecdotes. This is not the forum, and this is not the issue for fallacious reasoning, going from is to ought, for example. David Hume told us about that one. The fact that there happen to be same-sex families and same-sex relationships doesn't prove that we ought to have recognized in our society same-sex marriage. This is not the place for loaded slogans. I'm grateful for that. That's not happening here. What I like to call bumper sticker jurisprudence. Equality, due process, fairness, without any real boring down analysis. This is not the time for arbitrary assertions or emotional appeals or equivocation. Rather, it's the time to roll up our sleeves and look at marriage. Again, what this court said was the sure and noble foundation of this civilization. Now, as we come to this, we'll see then that Lawrence versus Texas, though I believe it was wrongly decided, and though I believe it's poorly reasoned, nonetheless, on its face, militates against same-sex marriage. And it does so even on the due process question. Because on the due process analysis, the jurisprudence of our courts have held, you have to have an asserted right that is, what, objectively and deeply rooted in this nation's history and tradition. That comes from the Glucksberg decision, which I believe deals with the ultimate, private, intimate decision, assisted suicide. And there the court said, no, we're not going to allow people, even if they're willing, even if they consent, to kill one another. That's a private context. How much more does that rationale apply then when we're dealing with not with just private choices, but we're dealing with a public institution of marriage? And so I concur, this is a radical idea, though it's not new. And it is a risky idea. And I think you'll find that there's many risks, and we'll get to the sociological issues a little bit later. The reality is, advocating same-sex marriage is like telling a geometry teacher to draw a square circle. You can believe it passionately, but you'll never be able to draw a square circle. Thank you.
I wanted to have a round of applause for all of our panelists.